Hey there, listeners. Welcome to Hines on Air, your weekly dose of inspiration, motivation, and real-life entrepreneurial stories. I'm Matt Hines, your host, and I'm excited to have you join me on this journey. From building a successful law firm to venturing into other industries like real estate and social media, I've experienced both the triumphs and the challenges that come with entrepreneurship. I've learned firsthand the importance of resilience, adaptability, and a relentless pursuit of excellence. On Hines on Air, we're diving deep into the world of business, law, and personal growth. Join me as I chat with incredible guests who have faced adversity, defied expectations, and achieved extraordinary success. We'll discuss their strategies, their mindset, and the lessons they've learned along the way. Whether you're an aspiring entrepreneur, a seasoned business owner, or simply someone looking for a little inspiration, Hines on Air is for you. Remember to subscribe, like, and leave a review whenever you listen to podcasts. Your support helps us reach more people and continue sharing these incredible stories. Let's get started.
Hey everybody, it's Matt Hines. We are back with another episode of Hines on Air. Thank you very much for joining us. We have an exciting guest today. This is Miss Shannan Collier. She's the owner of Law Offices of Shannan Collier. She's owned that for about 25, 26 years, and she's an expert in transaction law, business law, taxation, estate planning. She's got information today that everybody should know. I mean, I think you should probably be taught this in college just so you can get out and really do things correctly, you know?
Then I wouldn't have a job.
Well, okay, that's true. But they still need you. They might know better questions to ask or something. Because a lot of this stuff, I don't even think people know it's even an option.
I agree. There's a lot of times you don't know what you don't know.
That's right.
And they don't know to ask the questions, or that these are things that you can do to help yourself.
Yeah. And then you're kind of, if you don't ask and if you don't plan ahead, you're stuck in a situation that, I don't know. It's going to be a lot more difficult, if nothing else.
It can definitely make things more difficult if you don't plan ahead for the transactional things, at least that I do.
Yeah. All right, good. All right, so this show is about giving information about how people can lead better lives, take control over lives, accomplish goals and stuff. And we're going to get to that information, but it's also about entrepreneurship, stories of success, overcoming obstacles. And Shannan, you've overcome a lot to be where you are today. Successful business owner, from what we've said earlier, in the beginning, it wasn't easy, right?
It was not easy. There are people who've had it way harder than I've had. There's people who've been through what I've had. Yeah. So I don't like to say I've had to overcome huge obstacles, but I'm human. So of course I've encountered those things that have made things more difficult than it could have been. I became a single mother with a young child when I was still relatively young in practice.
And you were just starting your business then, right? Your company.
Yes. Yeah? When I was divorced about 3 or 4 years after I started my own business. Yes.
All right. So let's just so everybody can follow with us. You were working for a company that you eventually left, and you started. Can you take us through that step and why?
So I was working for a law firm, doing transactional work.
Right. And what's transactional work for everybody?
It's paperwork law. We say that's paperwork.
Writing contracts, reviewing contracts, leases.
Can be any kind of corporate document, any kind of transactional document, estate planning. Technically, it also includes real estate law, which I do not do. Mm-hmm. But I don't. It's not courtroom law. It's paperwork. It's what you do to hopefully prevent ever having to go to court.
Right.
And I was in charge of the transactional department of the law firm, and I had a baby. And literally the first day in the hospital after having an emergency C-section, I was getting calls from my law firm asking me where things were. Mm. And I was home recuperating from a C-section, and I was getting calls from my boss asking me things. I started working almost immediately when I got home. Luckily, back then, I'm a little old. So it was just after the computer age came in, and I was able to draft contracts, email clients, and get information. So I was able to work at home, and I was doing that. But that was not enough for my boss. My boss wanted me in the office 9 to 5, at least.
How soon after the birth?
He wanted me there immediately. Fortunately, because of the C-section, I was not able to drive for 6 weeks. Okay. So I was able to go 6 weeks. The first day I was cleared to drive, he expected me at the office, and I started going in. We all know Atlanta traffic, an hour there, an hour back. I was losing with my newborn, and I didn't like that. So I gave my notice, and walked out and started practicing on my own with a 2-month-old.
Wow. And you were married at this time, right?
I was married then.
Okay. So it's my understanding that there were some troubles with the marriage and all. And within the next few years, you were a single parent running a law firm. Is that correct?
Single parent with a 5-6-year-old and running a law firm, primary custody. So I took him to school every day, picked him up from school every day, took him to every extracurricular activity, picked him up from every extracurricular activity, and attended every event in which he was involved.
Jeez. That's amazing, Shannon. That's one of those things that probably most people can't appreciate unless you've lived it, because that's a lot. I did it just as a single bachelor with no children, and it's very difficult. But that's amazing.
Thank you. I didn't think about it at the time. It's just what I did because I believed it was more important for me to be there with my child. Mm-hmm. Not everybody gets that latitude, and I understand that, and it is no judgment against anybody else. Mm-hmm. There were days he had to be in after-school care. There were days when we had to get babysitters, but it was my objective to take advantage of my situation as much as possible to be there firsthand and raise my child myself. Like I said, luckily, my job allowed me. The downside, of course, is I was not making as much as maybe another lawyer would have been making. I could not work for a big firm. I couldn't commit to being somewhere. This is before remote, before COVID. The young ones today might understand you did not have remote work. It did not exist. And so I was not making as much. And that was the sacrifice, though, I was willing to make. It's a trade-off. Everything's a trade-off. It's a matter of which thing do you want more. Right.
We were talking about this earlier, like, did you have all? And I think that you said it correctly. What does all mean? It's going to be different for everybody. But in your opinion, did you have it all?
I had it all. I had a job that I love. I could hire or I could fire the clients I didn't want to keep. I could work for the clients I wanted to keep. I could do the work I wanted to do. I was with my child, and I did not answer the cell phone when we were driving to school. I didn't answer the cell phone when I picked him up from school or when we were on the way to or from an extracurricular activity. He knew I would talk while he was at an activity. He knew I would talk while we were at home. I would work, and we were on vacation. I would take those calls so I could afford that vacation. But there were times that were allotted for him. So my have it all was I got to be there for my son. I got to raise my son. I got to see every step. I got to do a job that I loved. I got to make enough money to make it all happen.
That's great. And he's a fantastic human being. In medical school.
He's in medical school.
Wow. What a success story. That's amazing. A lot of people, I think, would have your situation and feel stuck. Like, I can't do what I want, or feel they don't have options, or don't feel they can control that situation. They're just kind of in some circumstances that are, I don't know, they're just going to have to live through it somehow. But you seem to rise above it. You did it the way you wanted to do it.
Thank you.
Yeah.
I guess in some cases, there is a situation where you could be stuck. I am a make the best of.
Yeah.
And every situation you're in is a matter of choices. Whether it were made 20 years ago or whether it's made yesterday, every place you are today is a accumulation, a culmination of your choices.
Right.
So it's just a matter of what choices you make and how they've led you to where you are today.
Right. Well, you're working on two major aspects of your life: a child, a single parent raising a child, and working on the company. Yes. And we now fast forward about 25 years. And we have a child in medical school, a successful business company. So very well done.
Thank you. Yeah. Thank you. I love my practice. I'm so fortunate that, again, I'm able to work for clients I love. I have clients that, I don't want to say just clients, they're clients. And I'm so fortunate they're wonderful people. Yeah. I have clients that have become friends, and I have clients that have become best friends.
Yeah.
And so these are the kind of relationships I've been able to establish for the last 30 years. And I'm very fortunate. I've been practicing. I think it was 31 years this year, May. I've been practicing, and it's led me to where I'm able to meet people like you.
There you go. Nice. Cool. What's your busiest area of practice right now?
No.
No?
Nope.
What is that?
No.
It's too big. Everything's crazy, or what?
Everything is crazy.
Yeah.
And in the old days,
that's a good answer. No. All right.
In the old days, I'd said everything was cyclical. It's like, oh, this 6 months, estate planning is way up there. And the next 6 months, oh, corporate matters are way up there. And oh, the next 6 months, leasing or franchising. But No, it's all crazy. Everybody. I'm so fortunate that the area of practice I'm in, that when the economy is bad, people are laid off. They have to go start their own corporate companies or their own jobs, their own work, and I get business. Or the economy is good and people are doing business and they need contracts, they need documents, they need opinions or advice, and I've got work. So I'm fortunate that no matter what the economy is doing, I'm doing okay. And lately, there is no one area of my practice that is truly overshadowing any other. I am drafting documents, whether they be business related, estate related, franchise related. Everybody seems to be working themselves hard, which in turn makes it so I'm working hard.
Yep. I don't know what made me think of this. A while back, this was right when I had begun. So I don't know how long you had been practicing then. You referred me a case. You were like, Matt, this guy was getting sued by one of the major carpet companies. And you said, Matt, I've told my client he does not need to go alone. He needs an attorney there with him because they were going to be at the board table and negotiating. So I was like, sure. I mean, yeah. I went. I did not prepare that much. I did not know what the hell I was doing. And I remember being at that table, and I was so nervous. I couldn't move. And I tried to write. You know how you like take notes and looks like you're paying attention and really engaged and whatever, but you're just trying to distract yourself. I couldn't move my hand to write a letter, much less negotiate with these guys. It ended up, we survived. There was another guy there that kind of led the pack. I have no idea what reminded me of this, but it was funny because I'd never experienced that level of fear, complete ignorance. Like, what the hell am I supposed to do right now? I did threaten a counterclaim, like, we're going to sue you in return. And they were like, we're prepared for your counterclaim. And I was like, okay, I don't have anything else to say. It was bad.
Maybe people don't realize how much that we really don't know when we come out of law school.
That's right. It's a shame. You'd think law schools would evolve to the point of getting people prepared, but they don't. I don't think any schools do, except some of these trade schools. I have an MBA too, and you would think a master in business administration knows how to administrate business. They don't know jack. Most of them. I hate to criticize a school or somebody who graduated with, they worked hard, but if you have a marketing degree, I would like you to get out and be able to write me a marketing plan that's going to get customers, not like, well, I'll go get experience for the next 5 years. But anyway.
I got my MBA too, and I got to tell you, I don't know what I'm supposed to do with it, except for it looks really pretty on my business card.
It's cool. Yeah, those letters look nice.
And I do know how to read financial statements, which comes in handy when you're reviewing franchise documents. That's a great thing.
For sure.
And I do use it when I meet with clients, luckily, I'm able to understand business and marketing and strategies, and I integrate my recommendations with those facets. So I think that's what my clients do appreciate about me with having the business background. And for you, by understanding consequences, having enough of that business background, that probably does help you in making your decisions as well.
Yeah, it does.
So we may not know the practical little
That's true. I don't think we know exactly how every decision is influenced by knowledge from 25 years ago, but I don't know. Sometimes I wish there was a little more practical side to the schooling.
I agree.
That's a big debate these days. Okay, so let's go with some knowledge that our listeners can apply to life. All right. Now, you advise people in the realm of asset protection.
Partially.
All right. So give us just some basic mechanisms of asset protection. What do people do?
So the first thing is, if you have real estate that you're not living in, it should be in an LLC. That's almost a default decision. Now, if it's a common vacation rental of a family, I still think an LLC is great, because if you have multiple family members using a piece of real estate, what if something happens? What are the rules? What are the obligations of a family member when they're using this family rental property? So if it's not one of your primary residences and anyone else is staying, I believe it should be an LLC. So it provides rules, governances, and it prevents any claim against the real estate from attaching to your personal assets. So if you have a rental house and I stay there and I say, Matt, I fell and I hurt myself, I'm suing you. Well, you're going to say, well, really, you're suing the LLC because the LLC owns the real estate. And then if you get a judgment because we did do something wrong, then you're going to get a judgment against the LLC, which means my law firm and my house and these other things are all safe from your claim. So that is my one absolute. The next step.
You said if you're not living in it. So not a personal residence, you don't put in an LLC.
Correct.
Why?
Because if you do, you will lose homestead and over 60 or 65, depending on where you are, exemptions. You'll lose all those tax exemptions you get from having an individual own it.
Got it.
Now, the primary residence, what you can do is put it in a revocable living trust. By doing so, you haven't really protected it from third-party liability. But what you've done is it's got a few things, and this actually applies to the whole big picture of estate planning, but I'll just use it right now with regard to the primary residence.
Okay.
You do a revocable living trust. The real estate's there. You still can get homestead. You still can get the exemptions for tax purposes because a revocable trust is treated as though it's still yours. For the kids these days, I say, pretend it's in your digital wallet. So that's how I make the analogy for my younger audience. So you have it. What if you are temporarily incapacitated? Well, you've already defined in that trust what happens to anything held by it if you're unable to make decisions. So the house is there. Well, you're going to live in it and we'll bring in care for you while you're incapacitated temporarily. Well, what if you're long-term incapacitated? We've still provided for what happens. What if you're permanently incapacitated and now you have to go into a home? Well, in that case, maybe now your trustee will say, let's go ahead and sell that property, or maybe we'll lease it and make an income. And then we put you in assisted living because you are permanently incapacitated. Well, what about when you do die? Well, the property's in the trust, so now we're not dealing with probate. Right. And probate is the most understaffed, underfunded court system in the country. So even though Georgia has pretty much the cheapest, easiest probate in the country, you're still not out of probate, usually in less than 18 months, and that's like the low end. And the filing fees have gotten to the point that you're paying about $750 to get out of probate. That's with no attorney, no contest, no special filings, no special anything, just for the probate process itself. So you're able to avoid probate as well. So all of these things are great. Well, the revocable living trust should also have what's called, which of course now I forgot because of course we're filming, so I'm going to forget the word.
Let's see it.
It has a creditor protection provision. So what happens is if a creditor does come and try to make a claim and you want to protect those assets, you put your house in that trust, you are the trustee, you say, I'm surrendering my trustee provision to my successor trustee. So your successor trustee comes in and it locks down the trust and nothing can come out of it because you're not the trustee. You can't distribute it to you. So the successor trustee is able to lock down this revocable trust for as long as there's this claim, nothing can be distributed. And the creditor now loses its ability to go after the assets in that trust.
And it only kicks in if the creditor is after you.
Well, you have the right. Because if you're the trustee and they try to make a claim, technically you can't say, well, the creditor claim comes in because you have the discretion to distribute to yourself as the trustor or trustee beneficiary. But if we remove you from the trustee provision and you no longer have authority, you make that decision when you want to, when a creditor makes a claim. The other trustee steps in, it locks it down.
All right, so let's play that out for everybody. First off, that's brilliant. Let's so we said a revocable living trust. Revocable meaning you can put a house into the trust or you can remove it from the trust. So you can revoke the
as long as you have capacity, you can do it.
Okay. So it's all right, living means just while you're still alive.
You create it while you're living. It's not created in your will. You're creating it by signing it today and its existence the second you sign it.
Okay. And there are different, let's say I put a house in an LLC or I put it in a trust. There's just different laws governing how that property is handled?
Correct.
Okay.
So I hate to do that. I'm going to backtrack you. Sorry. Mm-hmm. So if it's an LLC, the reason we put real estate in a disregarded LLC is because when you ultimately sell it, you get tax benefits you do not get if you put it in an Inc. or an S election. So it's treated as though it's still in your own name for tax purposes. So we use the LLC for that to make it so you get all the benefits of taxes with all the protections afforded you. The revocable trust is treated as though you own it still directly. So for tax purposes, nothing has changed from when you owned it yourself.
Okay. All right. So let me play out a scenario. Let's say I have a beach house and I put that beach house in whatever, Sunset LLC. All right. So I set up my LLC. I transfer the beach house into Sunset LLC. I get sued and I owe people, I don't know, $500,000. Can they get to the beach house?
Okay.
Can they take the beach house?
So they can't get to the house. What they're going to try to do is get to your ownership interest or LLC interest in that LLC. But the operating agreement, when done properly and when not a 6-page document off the internet. Yeah. Oh, I just threw that out there. I did.
Yeah.
It has provisions as well that say, well, no one can force a distribution. Well, we can lock it down and so that if someone said, I want to either secure your interest in the LLC or I want to garnish your interest in the LLC, they are not able to act as a full-fledged member. They're restricted. They have the profits interest. So if that is a rental and it's still being rented and money's coming through and there is profits that would have been distributed, they can have rights to that. But the managing member, who's not that person, cannot force a distribution. So the money can sit in the LLC. So to date, typically the only creditor that has patience to go after that kind of situation is the IRS.
The ultimate creditor from hell. Creditor. That's right. Okay. All right. So you put it okay. Because everybody's, by default, if you're having this discussion, people say, well, you own the business, so therefore they can go after it. So, but if you put, for everybody, the operating agreement is just the rules governing how the LLC functions, is run and everything. Like every LLC has an operating agreement, right? Or should have it.
It's required by federal and state law, which is why I found it interesting when either an individual who's a single member LLC doesn't need one, or, I only need a little one. Because the federal tax laws mandate that certain language be provided if you want to be taxed as an LLC, and the state laws mandate that you have an operating agreement because it shows formality of the entity. Mm-hmm. So when people don't, or they don't have proper ones that follow state and federal laws, they subject themselves to piercing of the corporate veil and recategorization of taxes by the IRS.
Yikes.
I know, right?
Just so they don't have an operating agreement, they could have their corporate veil pierced.
Yes.
And for everybody who's listening, that means basically you don't get any protection. It's just like the LLC doesn't even exist. They're coming to you. Exactly. All right. So in my example, beach house, it's not rented in our hypothetical. It's not rented. Okay. It's worth $500,000. Okay. People I owe or whatever, they have a judgment or for some reason are coming after me for money. It's in Sunset LLC. We have a proper operating agreement that you drew up, Law Offices of Shannan Collier, PC. They could get to any profits, but I don't have any. They can't get to the house.
They can't get to the house. They can get to your ownership interest in the LLC.
But when you say that means if I own 100% of the Sunset LLC, then they're about to own 100% of Sunset LLC, right? Or no?
Yes. If one, they have to be able to get it, to levy that. So they have to go through the levy process. If they succeed, the operating agreement says all you have is the membership profits interest. You have no right to vote. The operating agreement has already defined that. So you might come in and be the owner, but you have no right to vote. You have no right to make decisions.
Who does?
Whoever we said in the operating agreement.
So you put if I'm managing member, I'm the head guy of Sunset LLC. We have that clause in there that says you don't get shit if for whatever reason. They then get the profits, interest in any profits
that are distributed as determined by the managing member.
So I stay the managing member. He just gets profit. He's kind of this other member that's only entitled to profits. Okay. Can I then give it to my wife?
Give what to your wife?
The beach house. As owner of the LLC and still managing member?
No, remember you want to do arm's length, or else that could be deemed a fraudulent transfer.
So, okay. So is there a way to, I don't know, tuck it over here underneath this rug or not really?
That is why you say that you've got to have the patience of Job. You have to outpatience the creditor at that point.
I got it. Gotcha. Okay, good. All right. Interesting. All right. Now we're going back to trust.
Okay.
Revocable living trust. We defined what that was. Now, Who are the major actors in a trust?
Okay.
Trustor, all that
So
good
you
law
have the
firm,
trustor,
law school stuff.
the trustor or grantor, same word. They're the people who person who establishes the trust.
Okay.
You have the trustee or grantee. That is the person who manages the trust. You have lifetime beneficiaries. Those are the people that have rights to current income and or principal distributions during the life of the trustor. Then you have remainder beneficiaries. That is after either the trustor dies or beneficiary dies, depending on how the trust is written, the people who might ultimately take. Now, the current beneficiaries, the lifetime beneficiaries, may be the only beneficiaries. They may be the ultimate recipients.
Right.
Or they may not. So it depends on how it's drafted. Typically with revocables, we have, let's use a married couple with adult kids. Easy peasy. So husband sets up the trust. Husband and wife are both trustees. So if one is unable to serve, the other one may serve alone. The other may always appoint a successor co-trustee to serve. So if they start feeling like they're not able to manage their assets, they then appoint an adult child.
Okay.
When both adults are unable, the designated successor steps in, who may or may not be that first child co-trustee appointed. So when both mom and dad have gone, we now have to go to the successor designated trustee. Might be the same kid, might be different. During mom and dad's life, they were the primary beneficiaries. All the assets are managed to and distributed solely for their benefit, or as they direct. They may say, I want to give $1,000 to my grandkid. They may say, I want to set up a 529 out of these assets. They can do anything they want because it's theirs. When they're both gone, we might give it outright to the two children equally. We might hold it in trust until they reach certain ages. We may have to set aside some because there is a special needs individual and we don't want to screw up Medicaid and Social Security benefits. We may manage it for their benefit and let them have income and then distribute it outright to grandchildren later on. We might give certain assets to certain descendants. At that point, we can be as creative as the client wants to be.
Okay. In the revocable living trust, let's say Joe Blow is your client. That's the guy, he has the beach house. And you want to protect that beach house for him. What's his role in this trust? He's trustor, of course. He's creating it. What other parts does he play?
He can be trustee. He can be co-trustee. He can be whatever he wants. If he wants to protect it, he would not want to be the trustee. I mean, if there's an issue soon, imminent, believed, he might then, if it were his beach house, he put it in, he created the trust. Wife can be trustee. Daughter can be trustee. Sibling can be trustee. Parent can be trustee.
I'm assuming if it's for asset protection, you would trust that trustee.
Exactly.
Okay.
Well, not just because asset protection. You want to trust that trustee, period, because they're managing your assets. Doesn't mean that you don't know what's going on, but you still want to trust the person that you're denoting as a trustee, a manager of your asset, whether it's one or multiple assets.
That's revocable too?
That is revocable.
So he's the guy, Joe Blow, puts his wife as trustee, but he can still revoke it and give it back to himself if she's trustee?
Yes.
Okay.
If it's written that way.
If it's written.
And as long as he has capacity.
Got it.
Now, he may rescind those rights. I have one client, husband and wife set up a trust, both trustors, both trustees. He started having threats against himself due to multiple activities in 3 different corporate entities. Nothing fraudulent. Construction.
Okay.
It happens, construction. Because he wanted to be sure that their assets were protected, he revoked his right as trustee and revoked his right to amend the trust personally. Not his wife, but he did. Mm-hmm. So now his wife is the sole trustee, the only trustor with revocability rights until that whole mess subsides.
And that gave him more protection.
That gave him, it totally protected him. Anything in that trust is totally protected from anything against him.
It can't get, there's no way to use him to get into that.
Exactly.
The assets. Okay. All right. So earlier we were comparing putting it in an LLC, and you talked about writing the operating agreement correctly so that they can only get profits. So how would we use this revocable living trust to protect that asset?
So then for the asset, wait a minute, let's back up.
Sorry. Yeah. I know earlier you had mentioned there's a clause you can put in the trust that the creditor something thing. So
spendthrift. The spendthrift provision, that's the term I couldn't remember. The creditor protection provision is called spendthrift.
Okay.
The same thing.
Okay.
Keep talking.
No, that's cool. I'm handing it off here. So I want to protect the beach house.
Well, we just went through all that.
In the trust?
Yes. We talked about appointing another trustee, revoking your rights of amending, surrendering that. Those are the only ways really to protect the assets in the trust, because otherwise you have the right to access them. Remember, like I said, if you're the trustee, you can distribute. But if you're not trustee, you cannot force a trustee to distribute because there's a spendthrift provision in the trust. Let me give you an example.
All right.
So Joe's got the trust. He's dropped that beach house in the trust. He wants his kids to get it eventually.
Mm-hmm.
Someone sues him. There's a provision in that trust that prevents it from being hit, to be able to have the creditors take money out of there, take assets out of there, force a distribution. But Joe cannot be the trustee at that point. We need another trustee. He's got to resign and let the other trustee come in because it's a conflict. How can someone who is being sued as trustee say, oh, no, I'm not going to let you distribute money out of that trust because of the creditor protection? So, but another trustee who's not Joe,
anybody
could come in and
spouse, mama. Okay, good.
But the key is, and I will tell you, Joe needs to resign as trustee prior to the filing of the lawsuit, or else it could be deemed to be too little too late.
Okay.
Now, I have not personally seen it where that's happened, but I could see a court not being pleased with Joe waiting until the lawsuit's filed. Now, if there's an incident or there's, money's getting tight or whatever it is, that is the time to step up and remove yourself from being the trustee. You need to know when things are happening or could happen, it's time to take a step back.
Okay. Good. All right. So LLCs and trusts, we've talked about them being used to protect someone's assets while they're alive. Okay, good. Now, before we started, you and I were having a chat and you mentioned some difficulties or some problems if ownership is not listed correctly. Is that?
Trying to remember.
You mentioned that there was a Medicare trust or something, or Medicaid trust, and it got somebody, and then they lost the rights to all their money. It's something crazy.
Okay, so
you give us a horror situation and the solution.
Okay, so clearly I like trusts.
Yep.
I use revocable, I use irrevocable.
Okay.
And there are times when Medicaid trusts, which is an irrevocable trust, are great.
What to define it real quick? Okay, go ahead.
So irrevocable trusts, once you set them up, for majority of circumstances, cannot be amended, modified, revoked, rescinded in any way, shape, or form.
So Joe puts his beach house in an irrevocable. He's lost.
It's locked down.
He can't just sell it to his buddy and make money. Like it's somebody else's. It's
right.
A trust.
Well, and technically you can't be the trustee. If you're the trustor of the irrevocable, you're also not the trustee, or else it's not deemed a completed transfer.
Okay. So
for the reasons you do an irrevocable trust, it would be moot.
Yeah. Understood.
So we set up an irrevocable trust because it is final. Because it's final, the IRS treats you not as owning it. Well, that's cool. That means creditors can't get it. Yeah, but it also means it's not yours. It cannot be distributed back to you for the most part. And you legally don't have control over. You have no strings attached to the assets that you put in this irrevocable trust.
Right.
Okay. Like I said, there are reasons for these trusts. Now, a Medicaid trust is a little bit of an irrevocable trust on steroids. It says, hey, to qualify for Medicaid, I virtually have to be penniless. I can have only nominal assets, nominal income.
Mm-hmm.
So people will sometimes use the Medicaid trust to put their assets into, use the assets, but I can't control them, but I can use them to an extent. And this way, when Medicaid does a search, I don't have any rights in or to these assets legally, and I can qualify for Medicaid. Okay. There are many times where proper Medicaid planning is fabulous. You have someone who is 70 years old. Mom is 70. Mom is now a widow. She's living on her own. She has one house. She has Social Security, a car, not much in the bank, no real reserve of assets. Medicaid planning might be perfect for her. Conversely, I have a client who's a married couple, and he is former military, he's former law enforcement, and he had a civilian job. So he actually has 3 pensions. You can't put pensions, retirement assets, in any kind of trust, and certainly not into a Medicaid trust.
Mm-hmm.
Okay. The only way to get rid of the pensions would be to get rid of them. And obviously, I don't want to say I don't have any right to this money because these are 3 pensions I earned.
Right.
Okay. So virtually, I can never qualify for Medicaid. It can't be done. I'm going to be making too much money after my retirement to ever qualify for Medicaid. So why would you create a Medicaid trust for that person, for that couple? You shouldn't. And this is part of the questions when you're asking a client, what are your assets? What do you have? What are your goals? What are your intentions? It all comes out in that interview, in that worksheet, in that discussion. So when I had a client come to me who unexpectedly, the wife died before the husband. Doesn't look a huge deal, except for the husband has 3 pensions and everything he owns, except those pensions, is in an irrevocable Medicaid trust. And he wants to do a bunch of stuff with these assets and he can't do any of it because they're locked down because they were a joint Medicaid trust and she died first.
Gotcha.
So it has just...
And they're just stuck.
He's stuck. And I can't go back after the fact and help fix him. I can't fix what is done. It cannot be undone because it is irrevocable, because it is locked down for a reason. And he was just not a happy camper that he was put in that situation. And I was unhappy that I couldn't help him.
All right. So was that an issue of how it's, yeah, I guess it is an ownership issue. Earlier when we talked, I thought the way title was vested or the way it was named might have been the issue. But this is just, you just put the wrong thing in the wrong instrument.
Correct.
Yeah. And it's stuck there. Yikes. Okay. All right. Well, that's just all going to the right lawyer, getting the right advice, isn't it? Yeah, unfortunately.
And maybe going to maybe just interviewing 2 lawyers before you commit to one. And I hate to encourage, 30-minute, hour-long consultations with multiple attorneys, because it's almost like getting 2 contractors to give you a bid on a swimming pool. Mm-hmm. It's rough. It's really hard. But with how important some of this information is, if you're looking at that situation, if it's not, I don't want to say it's not a simple situation, but it's, if someone's looking into something complex, whenever you're looking at complex estate planning, which is once you throw irrevocable in the word, you're now looking at complex. Mm-hmm. You probably want a second opinion. Yeah. If you're looking at pour over wills, revocable trust, power of attorney, medical directives, less of a concern. You definitely need them. You want them. You want someone to do them right. Less of an impact factor, because those are all modifiable as long as you're capacitated. And even if it's a joint revocable living trust, very often the surviving spouse can still modify because you still have one spouse there being able to do things. Mm-hmm. So you have that ability. So it's the extent of when you want something to be locked down, might be worth getting a second opinion.
No doubt. That's good advice. All right. Well, listen, that is fantastic information. Honestly, I think people could pay $500 or $1,000 to hear this from someone like in an event or a convention or something. But you've given them, I think it's something we all need to know. I mean, you really need to, because it's planning ahead, it's planning for the future. And when you need it, it might be too late. So it's good to find out now and do things right. So listen, thank you very much for your time.
Thank you for inviting me. It's been a pleasure.
Of course, it has been a pleasure. And anybody, if you have questions about what we've talked about, revocable trust, living trust, LLCs, the right operating agreements, this is Law Office of Shannan Collier, Collier. I've worked with Shannan. She's fantastic, very knowledgeable. She can make things a lot better for you. So anyway, if you have questions, please visit her website or give her a call. And to everybody that was listening, thank you very much for your time. If you're not already following us, please click on the follow button, subscribe to our channel, and we look forward to seeing you with the next Hines on Air.
Hines on Air is for you. Remember to subscribe, like, and leave a review whenever you listen to podcasts. Your support helps us reach more people and continue sharing these incredible stories.